a person required to appear before a commission, but who also happens to be facing criminal charges, can never ever testify before a commission prior to the finalization of the criminal proceedings.
May it please you, my respectful submission is, if I read, I've quoted for you from Justice Jafta's decision in the Zuma matter, and it's quite...
That was a minority judgment.
Yes, but still, I would respectfully submit, with the greatest of respect, Chairperson, that where you have constitutional rights, that those constitutional rights, especially in the very unique situation that my client...
You see, I'm raising the point that that was a minority judgment to understand on what basis you can then rely on that dictum or on that legal statement to suggest, in response to my general question, to suggest that a person who is facing criminal charges can never ever testify before a commission of inquiry.
I respectfully submit that when you have a person that's either an accused or a suspect, I respectfully submit that your constitutional rights, with the greatest of respect, override the compulsion that there would be from the commission side for him to give evidence. He would literally forego a large number of his rights if he is compelled to give evidence under those circumstances. I think what we've done, if you would just permit me, please, Chairperson, I think...
No, I just moved my shoulder. Yeah. I did not say anything.
No. I think respectfully, what I've endeavored to show to you...
You know what we always say in the legal profession, both amongst legal practitioners and people presiding, that when counsel says respectfully, they actually mean the opposite.
I was told that many years ago by a good friend that presided over a trial where he said, that was the impression. But I
sorry for interrupting you. I'm sorry. Yes, please.
I fully understand.
Yes.
The point is that is the nearest that we could come to any authority on this point. And this issue to us was so important that we were going to try and see if we could actually deal with this matter, if necessary, elsewhere. Where we are right now, I respectfully submit, we don't have to go there.
Where is elsewhere? Is it a court application?
Yes. No, only the approach would have been to actually make, if the matter were to continue, to make the necessary full-blown legal argument and submissions to you, and then depending on your findings to take it on review. I'm honest, I've indicated that to my learned friend before too. It's because we so strongly believe that your constitutional rights, where the Constitution is the most important document in this country, those rights cannot be taken away from you by a commission who's got a certain mandate and who's, to quote my learned friend, on a fact-finding exercise. And more so, I think what we've done, Chairperson, we tried to set out to you why we believe that the constitutional rights, especially in this case, overrides what, and we're not fighting with what our client is duty-bound to come and do at the Commission. What we say is, so far you've heard one side of the coin. This side of the coin that you heard, and you see, don't want to go into the details. As we said, we don't want to give away our litigation privilege in that regard. If we run our trial, we will show to you that what you've heard potentially is either not the truth or unlawfully obtained, etc. And for that reason, we will, at the end, of course, also assist the Commission in finding the truth in this, what I respectfully say is a quagmire of facts that you have to deal with. That is the one issue.
Or may I, before you go to the next issue, a difficulty that I have, and that of course is subject to your response, is that this is raised, or this is being raised in a blanket fashion, is the suggestion that any and everything that Mr. Matlala could ever say before this commission would be something that would be subject to the exercise of his Section 35 right? Is that what's being suggested? And that there is nothing whatsoever that he could ever say which would be unaffected by his Section 35 right? Is that what's being suggested?
That is not what I'm saying, and I think I've made that quite clear when I discussed with my learned friend. The difficulties that we find ourselves in at this point in time, and that was also the issue that prevented us from actually dealing with any affidavit beforehand, is that our client, and I was not party to that particular agreement, I only came in later, through a different legal representative with IDAC, the gentleman that's been named here was part of that, entered into to a 105A plea agreement. The magistrate then came back and found that the sentence wasn't just, and therefore gave all the parties time to go and reconsider. The issue that, that's when I got briefed to come back in, because there were very material and important issues that were not raised in the 105A that we believe would have materially influenced potentially the outcome of such an agreement. The only time that that matter could be dealt with, or the issues that was raised at that point, and if you bear with me, I have to choose my words carefully at this point because it's a very difficult situation, was when the magistrate finally made a ruling. So past Monday, that is 2 days ago, he actually, in terms, I think it's a 105 capital A 9B Roman 2, if I'm correct. He actually said, well, he asked the state, what is your contention? The state said, oh, we wish to continue. He asked us and we said, no, we assail from the agreement. What then happens in terms of the Criminal Procedure Act is that it's as if there was never any plea negotiations happened. The issue for me is, and this is where I want to answer your question, Chairperson, is we were not involved in those negotiations. We know what transpired and under what circumstances and in those negotiations. It doesn't take somebody to be a genius to having regard to what one's now learned, for instance, on Friday, what happened there. And my attorney and myself made the decision that we are not prepared to deal with any of these questions until such time as we are provided with the notes as to what transpired during these negotiations, as well as potentially any other documents that were drafted and signed. Because from the say-so that we've heard, it impacts on a lot of the questions we were asked to answer. And we are not prepared to just on somebody's say-so say, okay, we now exercise our Section 35 right on this and this and this. We want to come here as officers of the court, properly advising our client how that these are questions that you have to answer. You're compelled to answer them. You can't, let's say, invoke Section 35 rights. And as we sit here, Chairperson, we still can't give you an answer to that question because we still don't have that. So there is, of course, and that is the long and the short of it, there is answers that you can answer. But at this point, I can't come to you as an officer of the court in honesty and say to you, okay, this is my instructions. I need to, because of this quagmire of IDAC's involvement, be sure that what we say to you is truthful, because there's also the penalty of perjury, and of course there's a previous inconsistent statement that can be raised at any stage. So for that reason alone, I agree with you. There are issues, of course, you can never assail your compulsion to answer to those. But until such time as we can present to this Honourable Commission an affidavit that we satisfied contains, is based on facts and where we can invoke that right correctly, I cannot even go as far as to say we don't know this person. For instance, I could have come to you now because I know from the list, Annexure A, we could give you a list and say we don't know these people. But for the rest, it's not in your interest that we present, in your, and I mean the Commission, the Royal you, interest that we present in piecemeal fashion answers to questions. The fact of the matter is that my client has been made out to be this mastermind by everybody. And we respectfully, from our interaction, say that there's a fallacy in that. And we intend to show...
Please tell me when you are done with responding to my question.
Yeah. So,
before you move on to another point.
I've basically responded to your question.
Thank you. Let me tell you how my difficulty arose. It's because the affidavit does not clearly delineate the issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then ask you, does that mean there are no questions whatsoever that Mr. Matlala could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level, just...
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of the Section 35 issues. Why can't those be heard or dealt with by this commission before finalization of the criminal process?
So there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing and I need to understand in those negotiations who, what and where. And without that, I cannot,
Are you talking negotiations
with IDAC?
Relating to the plea deal?
Relating to the plea.
That's history now. I'm asking you about now. I'm asking you about now, please.
It's not history because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the Commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not committed to.
Is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about.
No, sir,
I'm asking you about the precedence.
Yes,
Which of the two processes must precede the other? So I understood you to be referring to the plea deal in the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end.
No.
That's something else altogether.
No, that's not what...
It has nothing to do with whether. Once the plea deal is dead and buried, must the commission process wait for the criminal process? So the earlier issue, the plea deal, is finalization or even non-finalization has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain to you.
All right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal. It's discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for what purpose?
For purpose of invoking my right to silence on that. I can say,
no,
I've been
then
told...
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that, post the plea deal, may also fall under the Section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside. And let's address our minds to those issues about which there is no question regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
Let me again try and explain to you, Commissioner or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying, I'm not interested in the nitty-gritty of what falls under the Section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of, on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. No. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket. Even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to your next point.
No, I do understand you quite clearly. The only issues that my client can answer, Chairperson, at this point, that we say that we form common cause on is who he doesn't know on the list of the 10-6. The rest of the issues, if I may please, the rest of the issues, I cannot say to you, I am prepared to answer this because I don't know if I can.
I have not asked you that. You are trying to answer a question which I have not asked you. I have not asked you that question. I have simply not asked you that question. I am asking you a general question. It has nothing to do with specifics, and that general question is, on those issues on which there is no question whatsoever, those issues, I will accept for a moment, for purposes of this debate, that there are plea deal issues that fall under the Section 35 basket, and which therefore will not apply to my general question. So I'm asking you this general question again, and it is this. On those issues which even you, whether today, tomorrow, or by the end of this year, there can never ever be a question about them falling under the Section 35 basket. On those issues, and again I repeat, this is a general question, on those issues, what would the basis of us not continuing with those prior to the finalization of the criminal process? What would the basis of not doing so be?
The only basis would be that the evidence will then be presented piecemeal. I've said to you, Chairperson, and I stand by it, the only things that he can say to you at this point, I don't know A, B, C, D, and E. The rest of the issues we cannot deal with. And I, with the greatest of respect, do not think it would be in your interest for him to sit here and say, I don't know this person, I don't know this person, I don't know this person. That's the only issues that we can form common cause on that he can at this point answer. We are trying to come to the Commission and answer what we can. The problem is, and I'm sorry to repeat myself, I can only do so if I know what he can answer is shown to me in black and white. I am trying to ensure that my client comes to this Commission and gives evidence to you that is to your benefit, i.e. the work of the Commission, and not for him to be to answer things that we as legal officers, and you've been in our position before, you can never allow a client to go on oath if you as the lawyer are not sure what he said there is right. I will not perform my duty as an officer of the court if I allow that. And for that reason, right now, I can claim privilege clearly on certain issues. I can say, this is my Section 35 issues. The others, I say to you, I can't at this stage because I don't know what's going on in the background. So it might even be once I've got the documents that I think is necessary for me to decide it, that we can move on that. But right now, we can't. And I respectfully submit that based on the remainder of the issues that we've put here, that this Commission should allow him the opportunity to finish the trial. And more so...
Again, please tell me when you are done
yes,
responding to my question.
And then the last thing is, I think the thing that concerns me the most is, and we've taken the liberty of sharing a privileged document with you pertaining to the opinion. The one
I think that's something else then. Can I come in? Yeah.
And when that is, for me personally, is very concerning at this point in time.
When you referred to a piecemeal hearing, this is just for clarity, does that mean you are going back on the earlier acceptance of what I posited to you, which was, is it something that can be done for this Commission to entertain proceedings that relate to issues that have nothing to do with Section 35? And I understood you to be saying yes. But now, towards the end of your submissions, you said, I don't know, I'm paraphrasing, I'm not sure of the exact words you used, but you said something like, it wouldn't be desirable to have a piecemeal hearing, something like that.
Yes.
Is that going back on what you said earlier, which was to agree with what I posited to you?
Yes. As I said, and the reason why I say piecemeal is all that will happen at the end of the day, Chairperson, is he will sit here and say, I confirm I don't know these people. And that is literally all we can do at this point. That is the only part of the Regulation 10.6 that we are at idem with each other. I say nothing prevents him from going under oath and say, I don't know person A, B, C, D, E, and F, and sit back. The rest of the issues, again, I want to emphasize, we want to cooperate. We've put it in our paper. But give us an opportunity to ensure that what we come to the Commission with is truthful. It's based on facts.
Another thing which arises from what you said in the context of the plea deal, and if I understood you correctly, you said this in the context of dealing with why a statement was not prepared. And again, if I understood you correctly, you made the point that you or your client had to wait until that plea deal process had been finalized so as to know whatever it is that related to the facts eventually. Here's a difficulty I have. Surely facts cannot change. Facts are facts. And I do not quite get it why Mr. Matlala could not have made his statement. He knows what the facts are, regardless of what the outcome of the plea deal were to be. He knew the facts, and therefore, from where I'm sitting, subject to your response, he could have said, these are the facts, and here are my responses to the notices that I have received.
But Chairperson, the situation is...
Or just to finalize, the facts could not be this or that, depending on the outcome of the plea deal. The facts are facts.
No, it is different, because when people enter into plea deals, there's certain consensus reached, and it goes, it's dealt with in totally different way, 105As, than what would normally, as you say, admit certain facts. If you go on a 220 or 115A and you admit facts, it's a different story. A plea deal goes beyond it. So very often, there's facts behind it. As long as that 105A stood there and the magistrate has not ruled on it, our submission is that the issues there, he could not entertain his Section 35 rights on those. He could not come to the Commission and say, listen, I'm a suspect or an accused on this particular matter, and therefore I invoke my right to silence. It's a live process, and that live process has many complex issues behind it. So for that reason alone, he could not depose to that to any affidavit here. I understand what you're saying, Chairperson. I understand what you're saying, but if he were to honestly depose at that point before Monday to an affidavit, he had to answer questions that we believe, because of him assailing from the 105A, he now has the right to invoke a right of a constitutional right.
But the Commission's interest would be facts in accordance with what Mr. Matlala knows, and that has nothing to do with whatever it may be that informed what he said for purposes of concluding the plea deal. So on that basis, I do not follow your response.
I stand by my response, Chairperson. I cannot, again, as an officer of the court, make my client say I invoke my right here and there and whatever, when I know in law the situation is that is a life process, and he cannot invoke that right at that point in time. The facts, with the greatest of respect, you say that you have to answer facts, but facts have context and facts have background. You might see something as a fact because you've got a General Mkonazi that comes and says, oh, he said A, B, and C. I come back and I can't exercise that constitutional right before you and say, whatever General Mkonazi said, he got out because the client was forced unlawfully and unconstitutionally to answer questions. He was not allowed, for instance, to have access to a lawyer. He was questioned for over 6 hours without food, etc. That surely influences that fact. Then it becomes no more a fact that we can rely on. It becomes a fact. And we know you are dealing with it as a fact because it's part of the process here. But it's a fact that was obtained unlawfully. And we have the right to make sure that you also know down the line that the facts that you rely on, General Mkonazi, for instance, say so, are not lawfully obtained facts. I can't come here and I'll say, please call so-and-so, put him in the box so I can challenge him as to how these facts that everybody now relies on were obtained. I can do that, however, because it's part and parcel of my trial that's starting on Monday.
It's exactly because there are those allegations, not only by General Mkonazi, but by many others, that the Commission wants to hear from Mr. Matlala, get his and underline his facts. You emphasize facts coming from General Mkonazi, and I add him and others. You emphasize those facts. What the Commission is interested now is facts from Mr. Matlala. But anyway, unless you want to comment on that, Commissioner Baloyi wants to ask a question.
Chairperson, as I said, those facts are facts that General Mkonazi rely on, that he says he obtained from my client. And we say what he relies on, you should not accept. And we can show you in due course why you shouldn't
We've not
accept.
accepted anything. We've not accepted anything at
No,
this
but I'm
stage.
saying to you, it's just one example.
Yeah.
If I can, unless you want to hear me.
Commissioner Baloyi has a question.
I just want to make sure that I understand what you're saying. I've understood you to say that you want access to the negotiations and the documents and everything that went on in the lead up to what would have been a plea deal that is approved by the court. And you say because you haven't had access to that, you're unable to get Mr. Matlala to respond to the notice that he has been given. Did I understand you correctly?
Indeed, because in that process that leads up, I'm sure, Commissioner, you've gone through those processes yourself. There's always deals that are made.
Your microphone is off.
Sorry, there's deals that's made. And that process to come to a finalization of a 105A involves a quid pro quo. And I need to see what the quid pro quo was.
But what does it have to do with the statement that must be submitted to the commission?
Because
let me finish my point. That process has concluded, even if what you refer to or what you describe as the quid pro quo were to be relevant to the answers in the statement to be submitted to the commission, which I'm not saying they are, even if they were to be relevant, that process has been declared in accordance with the law to be null and void. So for all intents and purposes, it never happened. That's what that concept means. Why is that a hurdle to Mr. Matlala submitting his statement, answering specific questions that have been put to him, and you know that in answering those questions, he's entitled to say, I don't know anything about it, and the assumption that we must make is he's going to be truthful in his responses, and if he doesn't know that's what it is. Why are the notes and the documents that comprise or that constitute what you say is a quid pro quo, why are they relevant for our purposes?
It's highly relevant because let's speculate. I don't want to go into detail, but let's speculate for a second. In order for them to offer this deal, they sit around a table and they say to my client, we want information on A, B, C, and D. And A, B, C, and D forms part, let's say, of your list. But A, B, C, D is not part of the plea agreement. That is the deal that we continue. We will enter into this deal with you. So, for instance, if there is, let's say, a Section 205, Section 204 affidavit opposed to, I want to see that because I want to see in that what transpired or what was admitted in that statement, number one. But number two, I want to see, and I feel very strongly about it, what transpired during these plea negotiations. Because in law, normally what happens, it's recorded. Because I have been quite about the fact that, I'm trying to choose my words very carefully. The process that was followed, I've made it plain to you, I was not going to be involved in it because I didn't trust it. That's the 105A process. And subsequently, I'm even more concerned about the process that was followed.
I understand.
And what I'm saying to you then is, in that negotiations, names could have been mentioned, admissions could have been made, evidence he could have disclosed evidence to them, and I can't deal with it if I don't see what happened.
That's information that's within Mr. Matlala's knowledge. I don't understand. I don't quarrel with you wanting to know for your purposes.